I'm going to be chairing the session. As you've just heard, the recording has started. So yeah, the session will be recorded, and we'll be sharing the slides and the recordings after the webinar's over, either later this evening or more likely tomorrow. We were talking earlier about why we wanted to do this session at this time and why we wanted to have this event on benefits at this time. Not necessarily today of all days, but I think in the context of a rapidly worsening cost of living crisis and the circumstances that a lot of our clients find themselves in, we thought that it would be timely to have a session on benefits and to have a review of some of the updates and changes in law and policy and legislation and case law as well over the last few years, as well as to talk about some practical issues as a sector, as much as that's possible to do in a webinar. One of the things I hear a lot from solicitors anyway, from my own perspective, is that a lot of people sometimes feel a bit sort of de-skilled in terms of working with benefits issues. They may be able to spot when something's gone wrong, or they may recognize that a client has other issues going on besides the immediate issue that might be in scope for legal aid. But because of LASPO, maybe benefits aren't something that people deal with on a day-to-day basis, or at least not as often as they used to. And I think that comes from sort of recognizing that very few clients, or at least the kind of clients that we all deal with, have just one problem. If you do housing work, if you do community care work, if you do immigration or any other kind of social welfare related law, then very few clients have only the one problem. And I think we will find that more and more people are having to engage with the benefit system. And so this felt like a good moment to try and provide this kind of event, to try and give people, to try and have an opportunity for people to talk and discuss issues and practical problems as well. So hopefully this session will facilitate that to the extent that we can do in a 90-minute webinar. So what we'll do first is hear from Bethan, who's going to be talking to us about updates in sort of policy and legislation. We'll then hear from Desmond, who will be providing a case law update on benefits issues in relation to renters in particular. And then we'll hear from Adrian, who will be providing us an update on things from a sort of EU free movement law perspective and talking about settlement scheme as well. Just to introduce Bethan a little bit more, Bethan is a very experienced practitioner specialising across different areas of social welfare law, but particularly working in housing, community care and court of protection work as well. Has a lot of experience in all kinds of benefits issues, and together with Desmond is the co-author of the Legal Action Magazine update on housing benefit. So with that, I'm going to hand over to Bethan, who is going to take us through her slides. So I'm going to hand over now. Thanks.
Thank you very much. Thank you. Thank you. I'm going to go to my slides. Thank you. Okay. Right. So I'm going to cover these topics: private rents, private sector rents and the local housing allowance rates, new exemptions to the shared accommodation rate of local housing allowance, universal credit housing costs replacing housing benefits, that's an ongoing process, the subject of no DSS blanket bans and what's happening there. And then I'm going to have a look at the debt respite scheme, i.e. breathing space, where there is some recent guidance. So just to take you then, first of all, to the first subject heading, which is the problems in meeting private sector rents because of the rates of local housing allowance, LHA. What is LHA? Just to recap, it's the maximum rate at which housing benefit or the housing costs element of universal credit is paid in the private rented sector. And how is that rate set? It's set at the 30th percentile on the list of rents in the relevant broad market area, which means that it's set at a rate which is aimed to enable access to the lowest 30% of rates of rents in any area. But that setting of that rate has really kind of fallen out of date. And what we have now is that the LHA rates set from the 1st of April 2022 are the same rates that came into force on the 1st of April 2020. So that would obviously imply that if there has been a raising of rents, that the rate no longer does in fact allow access to the bottom 30% of the rental market. So there's a problem arising from that lack of adjustment to the rise in rents since April 2020, since before the pandemic, because there has indeed been a rise in rents since the end of the pandemic. Rents have gone up. So that gives rise to the problem of the shortfall. And just a few facts and figures under this heading. First of all, 1 in 4 private renters in England depend on housing benefits to cover their rent. So we see that there's quite a lot of private sector renters who are dependent on housing benefit. The next figure is that the Department for Work and Pensions data shows us that there are 730,000 or just over households in England, Scotland and Wales who face shortfalls between their housing benefit, i.e. their LHA, and their rent. And the medium monthly amount of that shortfall is between 65 to 112 pounds a month, which is obviously quite a considerable amount in any household's monthly budget. That's the data from August 2021. So the gap between housing benefit and rents is obviously a major problem in what we see going on in housing benefit. Just going to go to my next slide. So remaining with the problem of meeting private sector rents, the wider problem is well documented in a number of recent publications. And I've referred, first of all, there to the publication from the Joseph Rowntree Foundation in October of last year. Renters on low incomes face a policy black hole. Homes for social rent are the answer. So the conclusion of this article is obviously in the title. So you can see what the problem is and what it points to. And one of the key points that they make is that 624,000 are facing unaffordable rents, which eat up more than 30% of their incomes, even after housing benefit is factored in. So that's quite a significant figure, because obviously spending 30% of your income on your rent is a really high proportion of a household income going on rent, and really indicates the general unaffordability of the private sector for a substantial group of people who are obviously having to depend on the private sector renting for their housing, which leads to the conclusion that the private sector is not providing a housing solution. The next publication is one from Crisis, supported by Zoopla, a recent publication looking at the rising cost of renting again, and noting that since the start of the pandemic, rents in the UK have risen by 12% on average. But, and this is the point that I was making with the first slide, housing benefits have remained frozen at the level set according to the rent data collected 2018 to 2019. So the housing benefit rates is very considerably behind. And then the Kerslake Commission on Homelessness and Rough Sleeping, which makes the following recommendation in view of the cost of living crisis, that LHA needs to be brought back in line with the bottom 30% of rental market. Finally, a Shelter publication under the heading "More than 1 million private renters hit with a rent hike last month." This was published in September of this year, and stating that the PM, whoever that may be, must at a minimum unfreeze housing benefit or face an explosion of homelessness. So that's how bad the problem is currently, and that's how much of an urgency there is for there to be a solution for private sector rents and benefits. Now I'm going to the good news in relation to local housing allowance, and it's the extension of exemptions from the shared accommodation rate to victims of domestic violence and modern slavery. So first of all, what is the shared accommodation rate? Well, local housing allowance claimants, so that's people who are claiming housing benefit or their housing costs under universal credit, who are renting in the private sector, if they are single and they live on their own and they're under 35, then generally the rate of benefit for their housing costs to which they'll be entitled will cover only shared accommodation, i.e. they will have exclusive use of a bedroom, but will have to share the other rooms, so living in a shared house, essentially. That obviously is a tough situation for people who have vulnerabilities, and there are a number of exceptions for various categories of individuals. Care leavers, for example, people who've lived in hostels whilst under resettlement schemes, and people who are entitled to some of the components of PIP and DLA are amongst those for whom there are exceptions. And I'd like to address a recent addition to that list of exceptions, which has come in under the Housing Benefit and Universal Credit Victims of Domestic Abuse and Victims of Modern Slavery Regulations 2022, which is a very welcome addition. And just to tell you how those regulations work, they amend the housing benefit regulations by amending the definition of young individual. And this works in the exception for victims of domestic violence and victims of modern slavery. And that in turn affects the scope of Regulation 13.5 and Regulation 13D. And as far as the universal credit regulations are concerned, the amending regulations amend Schedule 4, paragraph 29 of the UC regs, where there's a list of the exceptions to the shared accommodation rate. The new exemptions came into force on the 1st of October of this year, and there is a very wide definition of domestic violence, which is very welcome and good to see. So I'll take you to that. Sorry, excuse me. There we go. So the scope of this exception obviously requires looking at what is the definition of domestic abuse. And the definition as set out in the regulations is, first of all, the first part being any incident or pattern of incidents of controlling behaviour, coercive behaviour, violence or abuse, including but not limited to psychological abuse, physical, sexual, emotional, financial, regardless of sexuality or gender of the victim. And then there's a further definition of coercive behaviour, which again is quite appropriately wide, as you'll see, and of controlling behaviour. Again, that is a broad definition. And to look at the criteria then, when you put this together, that needs to be satisfied in order for a victim of domestic abuse to be able to fall within the exemption to shared rate accommodation. The criteria for the domestic abuse exemption are, first of all, after attaining the age of 16, had domestic violence inflicted upon or threatened against them by their partner or former partner or by a relative. There's a definition in the regulations for relative. And this is quite a peculiar way of establishing an entitlement, providing evidence to the relevant authority from a person acting in an official capacity, which demonstrates that the victim's circumstances are consistent with their having had domestic violence inflicted or threatened against them, and the victim contacted a person acting in an official capacity in relation to such incident. So it requires providing evidence that comes from a person of a certain category, which shows that your circumstances are consistent with having suffered domestic violence or having had it threatened against you, and that you contacted a person acting in an official capacity in relation to that incident. It doesn't need, as you can see, to have been the same person. So one of the key concepts there is a person acting in an official capacity, and you'll see the definition of that at the bottom of the slide: healthcare professional, registered social worker, employer, a public, voluntary or charitable body which has had direct contact with the victim in connection with domestic violence. Well, this is an area where it's crying out for some guidance. The guidance that I've found so far is fairly slight in the HB circular and the DWP ADM memo. I've extracted some aspects of what guidance there is, which are quite useful. First of all, that there's no time limit on making a claim for the exemption, in the sense that if the domestic abuse happened sometime way back in the past, provided that all the criteria are satisfied, that's no barrier in itself to making a claim. And the example is given of a person having suffered the abuse when they were aged 20 and making a claim at any time up to the age of 35. But of course, they'd have to produce the evidence in accordance with the criteria. And then as far as the modern slavery exemption applies, a person becomes entitled to the exemption upon having a conclusive grounds decision. When they've actually received that decision. If a person is waiting for their decision, then they're pointed in the direction of an application of discretionary housing payments in the meantime. And the further point is made that in order to benefit from this exemption, you actually have to be living in the self-contained accommodation. You can't claim the higher rate whilst living in shared accommodation. Now, I'm just, sorry, excuse me. Oh, here we go. How many people are going to benefit from this exemption? It's difficult to think how this estimation was made, but it's estimated around 11,000 people under the domestic abuse exemption and 1,000 under the modern slavery exemption. And the question that arises is, will people know to make the claim? People who are in shared accommodation currently, who won't necessarily know that the law has changed and that they can now actually claim to get accommodation that is self-contained. And so obviously it's very important that there is suitable publicity and methods of bringing this change in the law to the attention of these vulnerable groups. So moving to the next slide. Sorry. I'm now going to talk briefly about the process of moving from universal credit, from housing benefit to universal credit housing costs. So it's universal credit housing costs replacing housing benefit. And there's a lot that could potentially be said about this process. It's obviously been going on since 2013 and it's still going on. And the government's plan is to complete the move to universal credit by the end of 2024. I just wanted to make a few brief comments. One is that the move from universal credit from housing benefit to universal credit is by three methods: natural migration, a person just switching voluntarily. Natural migration is where there's a change of circumstances necessitating a new claim, or a person may decide that they want to make the change themselves, just voluntarily, or managed migration, where the Department for Work and Pensions writes to a claimant and requires them to make a claim. As regards managed migration, this is a process which has caused some comment and expressions of concern because of the difficulties that there may be for people in engaging in that process in responding to the DWP's contact requiring them to make a claim, which potentially, if things go badly wrong in that process, can end up in the person's benefits being cut off. And this was a point which was made by a whole group of charities who wrote to the government about that issue in May of this year. It's also been subject to comment by other organisations as well, and specifically in relation to the potential for problems for people who've got mental health problems in dealing with that process. One of the areas which is thought of as not really fully taken advantage of with regards to some of the problems in the switch to universal credit is the availability of alternative payment arrangements in relation to housing costs or in relation to universal credit generally. In relation to housing costs, it is possible to apply for payment of housing costs to be made directly to the landlord, as opposed to being paid to the claimant themselves. And this is against the background of there being quite a considerable amount of research which shows a link between a move on to universal credit from housing benefit causing rent arrears, increased rent arrears resulting from that shift. There's quite a lot of research which has shown that that there is a link. So with regards to the alternative payment arrangements, which are these what's supposed to be some sort of helpful measures that people can apply for, the take-up has not to date been terribly high. I have figures only for 2019. At that time, 20% of universal credit claimants with housing costs were taking advantage of being able to apply for payment directly to landlords. And as regards applying for more frequent payments of universal credit as opposed to the monthly payment, only 2% of claimants had applied for that. And the point has been made that that the APA guidance identifies mental health problems as a circumstance which might mean that an APA is required, but very few people access them. And when APAs are used, they're typically offered too late, after financial harm has occurred. And that is a point which is made in a very well-researched article about the link between mental health problems and problems with moving on to universal credit, a fit-for-purpose managed migration process, safeguarding claimants with mental health problems in the move to universal credit by Money and Mental Health Policy Institute in September of this year. So moving on to my penultimate topic, and I'm keeping an eye on the time, and I think I need to be pretty quick with my last two headings. So I'll be quick with this one. No DSS landlords. I realised on writing this that DSS actually ceased to exist in 2001, which shows how long this problem has been around. And we still very much have this problem, because figures in December 2021 showed that 52% of private sector landlords were unwilling to let to people claiming housing benefit. Obviously, that's a terrible figure. Initially, when I was putting this section together, I was thinking this is grounds for optimism. Things are going in the right direction. But of course, one has to take a reality check, because even though the law may be going in the right direction, we don't know what's actually happening on the ground and to what extent the law is actually moulding what is actually going on, in fact. But the law is moving in the right direction, and we had a whole series of successes in court using the Equality Act to challenge blanket policies against taking on tenants for private lettings using the Equality Act because of the discriminatory impact on women and disabled people. And certainly most or all of those successes were very much driven by shelter and were really well argued and well fought cases establishing in extremely important points of principle. And depending on, if I go over to the next slide, the very important research that Shelter carried out showing that 1.5 times more women were likely to be in receipt of housing benefit than men, and also people who are disabled 3 times more likely to be in receipt of housing benefits. So obviously disproportionate impact on them of these blanket policies. And then the white paper in June of this year, the government stating its intention to make it illegal for landlords or agents to have blanket bans on renting to families with children or those in receipts of benefits, and stating that it was entirely unacceptable to have these policies. So things moving in the right direction. We don't know what's going to happen next on that, so we'll have to wait and see. Very quickly then, to finish, the debt respite scheme, breathing space. This came in on the 4th of May 2021. It creates a moratorium for debt, which means that the creditor may not take any step in respect of the debt by way of requiring payment of interest accruing during the moratorium, or fees or penalties or charges to be paid during that period, or take any enforcement action in respect of the moratorium debt, which is defined in the regulations fairly widely. So the enforcement action that can't be taken is very wide. You'll see there in the list, take a step to collect the debt, or specifically in relation to housing, serving a notice or taking possession. So whilst the moratorium is in operation, if this scheme is triggered, there is a complete ban on enforcement action, and any action that's taken will be null and void. And I'll see right at the end of my talk, which I'm about to get to, there will be catastrophic consequences for anybody who doesn't know that and who proceeds with enforcement action in the face of a moratorium being in place. So quickly to the rest of this, there's a definition of a qualifying debt, and we have the breathing space moratorium and with mental health crisis moratorium, although I ought to say that the names of these concepts now seem to be generally the standard breathing space and then the mental health crisis breathing space. They're both being referred to as breathing space. You have to apply to a debt advice provider, and there has to be certification to the Secretary of State. The duration of a standard breathing space is 60 days. You can only apply for 1 a year. Sorry. Oops, excuse me. Oh, right. Right, sorry, my slide has actually enlarged, but it may be that it still appears in the normal size for everybody else.
I'm afraid you've zoomed in somehow on your slide.
Okay. Can I have some advice on this?
Are you clicking down on the mouse, or are you holding something on your keyboard maybe that's caused it to do that when you click through?
No.
Do you want to maybe come out of it and share it again, just so we can see the last slide? You're able to escape it. If you press escape, that should come out of the full screen.
Okay. Aha.
That's it. There you go.
Brilliant. Thank you. I think I'm fixed. Right. Okay. Great. Okay, so this is the mental health crisis moratorium, i.e. the mental health crisis breathing space. It applies where a person is detained under the Mental Health Act or is receiving any other crisis, emergency or acute care or treatment for their mental health. Again, application to a debt advice provider, certification to the Secretary of State. The duration is for the duration of the mental health crisis plus 30 days, and there's no limit on the number of the moratoria that you can have under that heading. There's guidance for money advisors, which came out in May, or was updated rather in May of this year. It confirms that breathing space is not a payment holiday. The debts continue to accrue, but the creditor can't expect the interest or charges to be paid during that period and can't take enforcement action. And emphasizes creditors must apply all the breathing space protections. And the purpose of the standard breathing space is to give the client an opportunity to make an arrangement with creditors in order to be able to manage their debt. Step Change is a debt charity, as I'm sure you're aware, which delivers a high proportion of the applications to this scheme. It provided a report in July of this year, giving a report of the outcome, which was generally positive, but acknowledging that in some cases people aren't able to resolve their debt within the period of the moratorium, and they still remain people with problematic debt after the period of the moratorium. And then finally, some case law in this area. And I've noted two cases there, and I'll mention one of them, Lees and Kay. This was a case which really, as I was saying, indicates that any creditor will ignore the moratorium at their peril, because in this instance, there was enforcement action by Mr. Kay against Miss Lees, whilst a mental health breathing space moratorium was actually in place. Despite that, he repossessed the property and sold it, and the buyer moved in. Miss Lees applied to court to set it all aside and did so successfully, and managed in obtaining an order which restored the position to what it was before the eviction and the sale took place. The sale hadn't been registered, but the purchaser had actually moved into the property. So that really underlined that enforcement action is null and void in the period of the duration of a moratorium under these regulations. That's everything for me. Thank you very much.
Brilliant. Thank you so much, Bethan. Really useful overview of the big changes of the last couple of years. I find it particularly striking how little guidance there is on the exemptions for shared accommodation. Like when you look at the ADM on the modern slavery and the victims of domestic abuse, it's literally about a page worth of text, and even that basically just repeats what's in the legislation. So there's bound to be a case, or I think, on that, and the interaction between what we mean by domestic violence, as it's called in the UC regs, and the person in an official capacity, and what that actually means, and what evidence is going to be required, and all that. I think it seems right for further guidance at the very least. Cool, thank you so much. Just as a reminder before I move on to Desmond, that we've got the Q&A function. So some of you have managed to put some questions in as Bethan was talking, so please do keep them coming. And yeah, we'll get to as many of them as we can. I'm going to now hand over though to Desmond Rutledge, who, as most of you know, is a very experienced benefits specialist who appears in all levels of courts and tribunals in relation to benefits issues, writes prolifically on benefits issues, provides lots of updates for us all in various publications. And he's going to be talking to us in terms of a case law update on issues around benefits that apply specifically where possible to renters. So I'm going to hand over to Desmond now, whose slides should be appearing on the screen there for you. Desmond, sorry, I think you're muted. You need to turn your mic on.
Sorry about that.
That's better.
My talk is about recent case law, but I'm just going to start off with some terminology for those unfamiliar with this area, though Bethan has just flagged up some. You'll recall that universal credit is paid in monthly, though each claimant has its own unique assessment period. It depends where they made their claim, but everything is by the month. And it has to be paid into one single account. There is provision, though, for some variations. So in Scotland, for example, they can opt to be paid every 2 weeks, but not in England. Everyone has to be paid 4 weeks, unless they make a separate special application. But the thing that I want to look at first is third-party deductions, which is the other side of the coin, not the payment you receive, but the deduction made on the payment you receive. So let's look at that next. So just a point that because universal credit is one big benefit all wrapped up together, when deductions are made from your benefits, they can eat into different elements of it. So although on paper, universal credit is made up of the standard allowance, which is covering your basic living costs, housing costs for your rent, and maybe parts extras for children and disabilities, etc. If a deduction is made, it's just made from universal credit. So it doesn't matter, it can eat into various parts of the makeup of universal credit. So this can cause problems, especially if there's a lot of variation in the amount of universal credit you receive. And that's particularly so if somebody is in a part-time work and their earnings go up and down. But the point I want to make is that deductions can eat into what person needs to live on. So the next slide is the amount of the deductions. Now, what was controversial about universal credit? Many things are controversial about universal credit, but one of them was the amount of the deduction that could be taken for overpayments and paying priority debts, etc. But because of political pressure, that has gradually changed. So it started at 40% of the standard allowance, but it's now got down to 25%, which is now getting pretty close to the maximum that was allowed to be deducted from legacy benefits, which is 25% of the personal allowance. So perhaps it's not quite so controversial as it was, because in the old days, a deduction from benefits was often a useful solution for someone's debt problems. But when the deductions got so large, it became a problem. Next slide, please. So this third-party deductions have been around for a long time, and it's been extended to universal credit, and you will recall that it's useful and can be applied to priority debts such as rent arrears, but also water and fuel costs. Next slide, please. Just to mention that the Work and Pensions Committee, when the cost of living started to really hit, they made the suggestion that maybe we should suspend deductions altogether, because that's what happened during the pandemic. But that was rejected by the DWP. And they said two things of note. One, they said, well, third-party deductions will just expose people to enforcement action by third parties. So it's better to have deductions from your benefits. And secondly, they made this general statement that if someone's really struggling, we'll always consider reviewing the amount of the deduction. Now that was the old attitude before universal credit, but for a number of years now, the DWP seem to have been unwilling to negotiate and reduce the level of repayments. So it's interesting that in response to the Work and Pensions Committee, they make that general statement. Anyway, moving on finally to our cases. So this first case is all about third-party deductions. Rather unusual. It's a very long judgment, 75 pages long, and it sheds a lot of light on this area. And the challenge was to the policy itself, the DW policy, and their main complaint was that the utility companies just sent a computer sheet with lots and lots of names and said, we want deductions from all these people. And they didn't need, under the law, they didn't appear to need anybody's consent. But the argument was that the individuals never had a chance to make representations before the decision was made to impose the deduction. And the High Court looked at the legislation, and then we move to our next slide. They looked at the guidance and concluded that the claimants were right, that it did give the impression that they didn't need to contact the individual before they imposed a third-party deduction. And the High Court concluded that that was in fact a legal requirement, and fairness demanded that they did that. The next slide gives a quote from the legislation. But 2 points to make. One, you might find it odd that how did the judge come to the conclusion that it would ever not be in someone's interest to have a third-party deduction, bearing in mind that it's water and fuel. What about disconnection? What about a prepayment meter being installed? What about the risk of a debt enforcement company getting involved? Well, the evidence before the court was that there were some particularly vulnerable customers for whom these were not real risks, and they could actually get a better deal directly with the company, or in some instances get away with not having to pay it at all. The court was a bit uncomfortable with that latter, but there does seem to be evidence that they could pay off the debt in a way that was less harmful. And so that was the point of them trying to get this point across, that they couldn't impose the deductions without asking them first whether they had representations to make. Moving on to the next slide. It's a similar problem that the DWP this time had a policy where they wouldn't consider reducing the level of the deduction for court fines. So again, we have the legislation. If we move on to the next. So the argument there was that, well, just having a policy of never making a deduction is better in your discretion. And they had no trouble in showing that. The other, well, we're not better in our discretion because you can go to the magistrates and sort something out with them. But the High Court didn't accept that that was a valid argument either. If we move on to the next slide, we'll see why. So it's that last point. If we go to the next slide, just sending them off to the magistrates wasn't really a proper response. And also, it's only the DWP could know what the deduction was doing and how it was helping or hindering the claimant, because they had all the financial details. So that's 2 judicial reviews that are looking at the policy and how it's implemented. So this shows the direction of travel in a way, looking at general policies which often aren't the subject of an appeal. I forgot to mention that in the third-party deductions, there was a right of appeal, but that didn't prevent the judicial review from going ahead. And it was accepted that many decision makers didn't seem to know about this right of appeal and mandatory reconsideration. So our third case in this same area, before I go on to it, next one, hardship payments, is the one I want. Just to explain what hardship payments are, that if you are subject to a sanction and you run out of money completely, there is something called a hardship payment that can be applied for on a discretionary basis, but you have to pay it back. So the issue that came up is whether the DWP had the power to waive recovering those hardship payments. So the next slide will show us that the Public Law Project issued a judicial review the decision was never published because they got a consent order whereby they got everything they wanted, and the DWP accepted that they could waive recovery, and they altered the there's a section on the Public Law Project website, but the next slide shows that the official guidance was changed to reflect this. And the second part of that sentence, the discretion can also be exercised by cancelling part of or the entire overpayment through the process of waiver or write-off, is a reminder that any overpayment, you can actually ask them to look at it again. But if you are going to do that, do have a look at the guidance at 8.10 to 8.14, because it gives very specific guidance as to what they need and what factors will take into account. And you'll discover that if you say it will affect the person's health, you have to have medical evidence to actually shows a causal link and how it will improve things. And you also have to place the DWP arrears debts into context of all other debts. So effectively, you have to put together a package to show why it should be waived, and they want things to be done in a certain way. So that's not useful guidance, but essential guidance if you ever go down that route. And most people will probably be aware that the DWP, as a percentage, waive only a tiny percentage of overpayments. But you would have more prospect of success if you do have regard to this guidance. Next slide, please. Bethan's gone through this, but just to put in context, it's my understanding that landlords are more than happy to set up a managed payment, and there's something they're in favour of, and they can now do it through an electronic link. That's social landlords. Private landlords, it's not so straightforward. But as I understand it, there's not much resistance to setting them up. But it's a reminder that if somebody does disagree, there's no right of appeal, though you can ask for a review, and there is guidance. So does this mean this could be the next area of case law? Who knows? The next slide just continues the same theme. And that's just a reminder of where all that guidance is if you do get into difficulties. And the alternate payment arrangements, which is an umbrella term for changing how the payments are made. For example, for 2 weeks, every 2 weeks rather than every 4 weeks, or maybe be paid to somebody else altogether. The factors that they take into account are in an appendix to that guidance. So more cases, I think, is coming up next. Right. I've got about 4 minutes to go through all these cases. Let's see how we do. First case came, complaint about using the 52 weeks to calculate the rent, because over a period of 4 years, 1 week is missed out. But the court refused to bend on that. And a thing that did come up in that decision and others is that using a 4 weekly ratio was crucial and central to universal credit. And any variation of that, the whole thing would collapse. The next case succeeded at the High Court but failed at the Court of Appeal for the same reason, that it would have meant introducing manual changes, and it would have undermined the reliance on the 4 weekly, 1 calendar month payment cycle. And there's some quotes from our MP that explains why the courts were unwilling to bend to that challenge. The next slide has 2 more examples of the same thing. Paying for childcare up front. Again, they would not change that because it upset the whole system. And so my point at the end, they want everything's been. The computer has taken over. They want it to be automated, and they don't want the design to be changed or altered in any way, which seems to be the current position. Whether that will change in the future, we'll have to see. Wait and see. Next, please. Back to the upper tribunal and bread and butter issues. Something fairly controversial, that if you want to backdate your claim by 1 month, you can attempt to do that after a decision is made on the claim. The DWP has been refusing to entertain those applications, but the upper tribunal has ruled that they can. The next point, it had always been thought that if you had made an application for a national insurance number, been to an interview or whatever, or you had an interview booked and you're waiting for that to come through, you could receive benefit in the meantime, but that's no longer the case. You must have actually been allocated, and before any benefit can be paid. So that's a new point. Next, please. This is just a reminder, in Northern Ireland there was a human rights challenge. It was based upon the difference in treatment between those on remand and those with short sentences, 13 weeks and 52 weeks. That didn't get very far, but what may be of interest is that interim relief orders was issued within those proceedings until the test case was decided, i.e. some benefit was paid until the final case was heard. So that might be something that comes up again. Next, please. The first one is the familiar position of somebody has to show they're a qualified person under EEA regs, but the spouse cannot be contacted or they're estranged, and you can get a tribunal to issue an order. And in this case, the district judge kept on refusing. So the upper tribunal helpfully suggests that you should explain the steps you've already taken before you write to the district judge. The next case, a bit of an obscure case, that someone who is a director running a business, the capital assets may be disregarded if they are actually still running the business. Something to bear in mind for those occasional cases. Next, please. Orphan Forest, that is a foster carer who had placements, various placements, and it's how the various rules work, bearing in mind that if you have a placement for, if you have occasional placements, then the disregard for the bedroom tax can last for up to 52 weeks. And bearing in mind that if the placement reaches the age of 18, then the position changes and non-dependent deductions may come into play. All a bit complicated, but it's all sorted out in that case. The next case, this is something that is very familiar to housing practitioners, where somebody asks somebody to move in as a caretaker while they're away in prison, as it happens. Well, that ran into a problem in this case because the person asked their girlfriend to move in after they'd gone into prison, and the girlfriend gave up their accommodation elsewhere and then moved in. and the tribunal notice that the provision says they need to make the payments to continue to live there. And of course, they weren't in the dwelling at the time the tenant was liable. And so the whole case fell to pieces on that basis. Next, please. That's just another foster carer point that the local authority got themselves into a bit of a twist and thought they couldn't disregard earnings because the foster care was by an improved independent agency, but they were wrong. And unusual case, MP Sutton, where somebody was paid the wrong housing benefit by mistake. They changed all their arrangements so that they could get more housing benefit. And it turns out that the first claim had been paid incorrectly, and so they would have got the same all along. So they couldn't fall foul of taking advantage of the benefit system. Bit of a one-off maybe. Next, please. This is just a reminder that this very rigid way of dealing with earnings still applies despite the success in Johnson. Johnson turns out to be a bit of a one-off. And the last one, I believe, is a little bit of good news where somebody was overpaid and didn't realize they're being overpaid. And the first tier tribunal said that the letter, which is reproduced in the upper tribunal decision, was easy, straightforward to read, but the upper tribunal judge took a completely different view and found it very difficult to follow or read, and the appeal was allowed. I think that's everything. Yeah, that's me done. Thank you.
Cool, lovely. Thanks, Desmond. Yeah, always really useful to have that kind of overview of the different case law that's been published in the last couple of years. And yeah, I just think it's good to get sort of different ideas and angles on issues that might come up for different clients and different remedies that might be available as well, particularly issues around kind of interim relief where that might be needed, and where some things might be appealable and some things might be more suitable for the first tribunal. So yeah, thanks very much for covering all that. All right, so I'm going to move on to our third speaker, who is Adrian Berry, whose practice spans a range of related public law areas, including immigration, human rights, international protection, and welfare benefits. Adrian's acted at all levels, including up to the European Court of Justice in relation to welfare benefits issues, and is going to be talking to us on benefits issues in relation in particular to EU free movement law and issues around the settlement scheme. So I'm going to hand over to Adrian now. Thanks very much.
Thanks very much, Matt. I'm just going to share my screen and my slides. I can get going. Oh, it hasn't quite worked. I'm going to stop sharing and try it again. Just bear with me. There we go. That might be better. I think that's better. Right, excellent, excellent, excellent. So not completely useless. Okay, so I'm going to talk to you about EU stuff in the context of benefits and access to social assistance, and of course that is the prop in relation to securing accommodation. And so there's the link. There are still lots of EU bits and bobs which are hanging over from our time in the EU and from the transition period at the end of our EU membership, which of course ended on the 31st of December 2020. There are lots of periods of time in which people might have had some entitlement or no entitlement or more than one entitlement by virtue of their connection to EU law, or they may have some continuing status under the withdrawal agreement, under the citizens' rights provisions of it. And so the issues which come up in terms of looking at who is eligible for what and when continue to be of interest. And it's important in that sense to keep up. It's also true that this is tailing off to some extent for new arrivals, people who are arriving in the UK, unless they're joining a family member and have some qualifying connection to EU law. But for the moment, there are a lot of people who are affected by this, including people with so-called pre-settled status, which is a form of limited leave to enter or remain, granted under the immigration rules and under the Immigration Act 1971, and which is granted in the operation of a scheme in the immigration rules, as we all know, to give effect to obligations on the plane of international law that arise under the UK's withdrawal agreement with the European Union. That also simultaneously, the immigration rules in Appendix EU also make some provision which is not within the scope of the withdrawal agreement, but which nonetheless the UK government has decided to put in anyway. And so a classic example of that is the so-called Zambrano right to reside, which is now embraced as a Zambrano form of leave to enter or remain for the primary carers of British citizen children in certain circumstances. So not a free movement case, obviously. So pre-settled status, there was a bit of back and forth in the courts and the senior courts about whether or not prior to the end of the Brexit transition period, it gave you some form of lawful residence, which meant that you couldn't be shut out from social assistance on the basis of your immigration status because you were lawfully resident, and you could rely on the general prohibition at treaty level on the non-discrimination on grounds of nationality in Article 18 of the Treaty on the Functioning of the European Union to say, well, I'm lawfully resident, I'm an EU citizen, I can rely on Article 18, it's a high-level law, the EU treaty, higher than UK law where there is a conflict, and it would be discriminatory to shut me out of access to anything where it has an immigration-related test in that context where the British citizen is entitled to. And so this issue got batted up from the High Court to the Court of Appeal and to the Supreme Court. And at the same time, of course, as we all know, there was a reference from a court in Northern Ireland to the Court of Justice. And so we ended up with two judgments. There was a case of CG at the Court of Justice of the European Union. And then having been in the Court of Appeal, the case of Frutilla reached the Supreme Court after the judgment in CG. And so that took a point that, well, yes, of course, there is this general provision on non-discrimination on grounds of nationality at the treaty level in Article 18, and it does govern the situation of EU citizens in many circumstances, unless a non-discrimination clause has been specifically provided in a specific context by EU law, in which case it will trump and displace the treaty level provision. And so what it's really saying is there is this general catch-all treaty level non-discrimination clause, but in the case of free movement, we of course had this free movement directive, 2004, 38 EC, and that had its own non-discrimination clause in Article 24. And in that it said, well, you have to really be exercising rights of residence under this directive in order to benefit from the non-discrimination clause. So not just anybody, but you had to be doing an EU thing, like being a worker, self-employed, a student, or self-sufficient, or the family member of such a person. And unless you were doing that, you weren't entitled to reliance on the non-discrimination clause. And so the result of that was that if you had pre-settled status, which is of course this form of leave to remain, limited leave that the Home Office was administering, even in the Brexit transition period before EU rights ran out, but you weren't doing the underlying EU thing, you couldn't rely on the non-discrimination provisions in EU law, non-discrimination on grounds of nationality, in order to say, well, I should be entitled to universal credit or any other cash benefit that has an immigration eligibility test, or indeed ultimately, of course, it would also, the point would also be good in relation to homelessness assistance or allocation of social housing under the Housing Act, so 1996. So all of that happened as a result of the interaction between the judgment in CG, which you can see in the final bullet point on the screen, and the UK courts, who were obliged to look at what the Court of Justice had said as binding on them in the light of the judgment of the Court of Justice, and to apply it in the context of the Frutilla case, which by this point had left the Court of Appeal and reached the Supreme Court. So that's where we ended up with that. A pre-settled status, if you were sort of population of people prior to the end, because this doesn't apply to people who make applications under withdrawal agreement rights after the end of the Brexit transition period, but in the period beforehand, for that period of time, those persons were divided into, if you like, into the sheep and the goats. If you had pre-settled status and you happened to be luckily enough doing an underlying EU thing like being a worker, then of course you could rely on your worker status. But if you had pre-settled status and you were neither economically active or otherwise self-sufficient, and you weren't the family member of a person who was, then you would be shut out lawfully, and EU law was not going to ride to your rescue in terms of applying the principle of non-discrimination on grounds of nationality in order to give you the result. But that wasn't the end of it, because and the sting in the tail of the CG case was, well, it shut out reliance on non-discrimination on nationality under Article 18 of the Treaty on the Functioning of the European Union. But then it went on to do another thing, which was to have a look at this question of fundamental rights as they arise under the Charter of Fundamental Rights, and to say, as regards the obligation of the national authorities of a member state, could fundamental rights ride to the rescue where you are lawfully resident in a state. So a French person, French citizen is lawfully resident in the UK. They've got pre-settled status. That's why they're lawfully resident. They're not doing anything in the sense of being economically active or otherwise self-sufficient. Can the Charter of Fundamental Rights apply to ride to their rescue? And so what the Court of Justice said, of the European Union said in the CG case was whether such a person legally resides in that country, the national authorities who are empowered to grant social assistance, whoever they may be, say like the DWP, local authorities and so on, are required to check to see their refusal to grant such a benefit does not expose that citizen and the children for which they're responsible to an actual risk of a violation of fundamental rights. And of course, we've got Article 1 in relation to human dignity, Article 7 of the Charter of Fundamental Rights, which tracks Article 8 of the European Convention on Human Rights, the right to respect for private life and family life. And then, because it's the Charter and it's a bit more generous in the ECHR, Article 24 in terms of the rights of the child and best interests, which we're also, of course, familiar with from the UN Convention on the Rights of the Child. So that wasn't an obligation on, for example, the Secretary of State for Work and Pensions to grant a particular cash benefit, but an obligation on national authorities to ensure that fundamental rights were protected. And so we ended up, so where an EU citizen doesn't have resources to provide for their own needs and for those of their children, that they must still be allowed to live in dignified conditions, because Article 1 relates to human dignity. We don't talk about that sort of term quite so much when we're using the ECHR as our catalogue of fundamental rights, but it resonates throughout the jurisprudence, throughout the case law of the Charter of Fundamental Rights. And so it relates and connects to the sorts of issues that come up under private life and family life about human dignity, the avoidance of inhuman treatment, and it interacts, of course, with the provision in Article 24 of the Charter of Fundamental Rights in respect of the best interests of the children. So, and it says that the judgment, the CG case, says that authorities, so national authorities, must take into account all means of assistance provided by national law, for which the citizen and her children are actually entitled to benefit. And so that sounds very good. You think, but it doesn't specify from where, which national authority, and what sort of provision must be put in place in order to avoid a breach of human dignity and effectively human degradation as a result of being left destitute. And so the question arose, well, might there be circumstances applying this bit of learning from the CG case to say, well, okay, we're shut out. We can't rely on Article 18 of the Treaty on the Functioning of the European Union, non-discrimination on grounds of nationality, to get cash benefits if we've got pre-settled status alone and nothing else. But can we rely on this bit of the Charter of Fundamental Rights? And the ADM memo, 1 of 22, makes no mention of the duty on the Secretary of State to consider a risk of the violation of an EEA national's rights and EU citizens' rights under the Charter before refusing universal credit. Is this lawful? And the answer to that from the minister in concern from the Department for Work and Pensions was, well, yes, effectively it is lawful, because we've got no current plans to update the guidance, and that we don't accept that this Charter of Fundamental Rights law has any application to situations governed by the rules in place after the end of the transition period, well, that must be true, even though it might colour a lookalike analysis under the withdrawal agreement. So that's a bit of a nitpicking point in terms of the thrust of the judgment of CG. But nonetheless, for periods before the end of the transition period, and this is really the substance of it, whether you're dealing with something before or after the end of the transition period, the DWP consider that to the extent that the Charter applies, the state's obligations are satisfied by the availability of alternative sources of support. And so that could be, for example, Children Act support in kind to a family, a parent with a child, or Care Act support if that was a relevant threshold. And so what they're saying is you can't just say, well, I'm entitled to this benefit, this cash benefit, universal credit in reliance on CG, because it doesn't fall on one emanation of the state by itself. It's the state authorities as a whole, the UK as a whole, and its public authorities has an obligation. So, but it's a bit of useful law, and it's worth bearing in mind that if you have been shut out from universal credit and you have to turn to a local authority under one of its statutory jurisdictions for providing benefit in kind rather than cash benefits in a situation of destitution, this bit of law is there to say, well, national authorities as a whole have an obligation to provide this. So whoever's the last national authority standing, if you like, the end of the line, which usually is a local authority in some capacity, that this bit of law applies to them. So, so worth bearing in mind that there is a statement on that. If you wanted to constrain the Department for Work and Pensions in respect of cash benefits, you would have to develop an argument as to why CG is binding and the provision provided by local authorities is inadequate to meet, on the particular facts of the case, to meet the requirements that the Charter of Fundamental Rights imposes in respect of the persons concerned. That somehow under the Children Act or under the Care Act, the local authority, or under the Localism Act or whatever, the local authority can't do what it's supposed to do. There's no other public authority left standing, and only a cash benefit would suffice. So that's the sort of threshold, or the high threshold you'd be looking at. Just remember, in respect of EU law, don't forget that there may be, a person may have more than one sort of EU law status, whether it's as a family member of a particular person, such as a worker or a self-employed person. They could be the direct descendant, they could be the parent of somebody, and a relative in the ascending line. They could be the spouse or civil partner of somebody or who has, or an unmarried partner who's got a residence, a registration certificate or a residence card. They might be the principal person, you know, the worker, the student, the self-employed person. And in addition to that, or they might have one or more of these statuses in addition to holding pre-settled status, which is the sort of strikeout thing that by itself, simpliciter, doesn't get you anything. So it's always worth reminding, and of course, at different periods of time in respect of which a claim is being made, a person may jump in and out of one or more of these statuses. So, you know, marshal all your arguments. Don't forget the full plenitude of EU law. It's a bit de-skilled not being in the EU anymore, because you sort of forget just how much EU law is out there sometimes, you know, for the periods of time. But for us, when we're working in the field of cash benefits and benefits in kind with immigration tests, then we are looking usually often retrospectively to look at periods of time to see whether permanent residence was acquired, what sort of status was a person held at a particular time. And so I've given you the link for a very useful template skeleton for pre-settled status and access to benefits, and also that and also just a nudge to remember that, you know, complete your analysis for the relevant periods of time. It may be a bit tricky and it may be sticky to sort of figure it all out, you know, chronologies and all that sort of stuff is very much the way ahead on these things, and dividing up periods of time depending on not only what is the principal person doing, but what are family members doing, because that can create some useful statuses sometimes. And of course, remember that some EU statuses, like being a job seeker, only took you so far in terms of accessing benefits, whereas other EU statuses, such as being a worker or being self-employed, in other words, being actually economically active rather than trying to be, took you much further in terms of being qualifying rights to reside for access to various benefits. And so the point about that is to remember that just because you've got a lawful right to reside under EU law doesn't mean it's a qualifying one, and this is before we get to the habitual residence test. And so it has, remember that there's sort of three-stage analysis. Do I have a right to reside or more than one? Is it a qualifying right to reside? And insofar as habitual residence covers the domain of, or the period of time which I'm looking at, does it apply, and is it satisfied in the case in question? The other points to note from EU law that really is, can a person seeking to show self-sufficiency to establish a right to reside or having accumulated 5 years so that they have a permanent right of residence rely on NHS healthcare to show they have comprehensive sickness insurance? Well, the case of VI against the Commissioner for Revenue and Customs, very useful case, because the UK, of course, has had a relatively open approach, because the UK test on access to state-funded healthcare is a residence-based test, sort of, are you here? And they took a relatively liberal approach in residing here towards EU citizens. That in that case, where somebody was, in the language of the court and of EU law, was affiliated to the United Kingdom's public sickness insurance system, offered free of charge without any sort of insurance payments or co-payments or so on, then that person was considered to have a comprehensive sickness insurance under the Free Movement Directive. So very useful case. Well, one can only lament that a case like this wasn't promulgated decades earlier or years earlier in looking at it. But of course, you see in paragraph 69 here, which I won't bore you with by reading it out, the Court of Justice looks at the idea of, well, what could the UK have done? Could it have insisted on people getting, in order to establish comprehensive sickness insurance, having private sickness insurance? What various things they could have done, which would still have been proportionate. But the fact remains that once you have a system like this and a person is affiliated to it, so in other words, they are eligible for NHS care in normal speak, then they have comprehensive sickness insurance. And so it's a useful judgment. And then we see looking at the case of WH against Paris County Council and the Secretary of State, that the anti-test case rule doesn't prevent housing benefit claimants, plural, from relying on that ruling, that affiliation to the NHS satisfies comprehensive sickness insurance for the right to reside. So a little bit of the application of that case this year in a very, very short judgment, but very useful judgment in respect of just clarifying a position which sort of might have been obvious in terms of the extent of the sorts of benefits to which the anti-test case rule applies, but nonetheless makes sense in this context. But just, the case really cited for that proposition about the anti-test case rule, but also just to remind us just quite how far things moved in the dying embers of EU law in this jurisdiction. We got to a really good place in some respects on this issue. And then just finally on this brief tour, just to remind you that, as I sort of said a moment ago, that a person may have both a qualifying and a non-qualifying EU right of residence, so don't get spooked by the fact that they've got a non-qualifying one. Continue your inquiry to see. So here you see a classic case where someone has a right to reside as a job seeker, which from an immigration perspective is job done. You've got a lawful residence in the UK, but it's a non-qualifying right for most cash benefits outside of a particular situation that came up in the Collins case at the Court of Justice many years ago in respect of job seekers allowance. And then you see also that person also had a derivative right as the primary carer of a child of an EEA national, or bound-bast right, to call it, or Teixeira or Ibrahim right, using the names of those cases. And then in that situation, in Sandwell against KK and the Secretary of State, you can see that if you have overlapping rights, the qualifying right can still be relied on, the one that gets you access to the benefit in question, citing that case of job centre Krefeld Widerspruchstelle against JD, and so you can from the Court of Justice. So so that's a really helpful just reminder of what's always been the situation, but it's very useful sometimes just, you know, as an aid memoir, just for us to go through that. So that's our little quick tour of EU law issues in this area. I mean, just to note that just finally, very briefly, that well, obviously there is no free movement, and there are no issues, no new free movement cases sort of for people moving here as such coming through, but we probably expect closer arrangements in years to come, some form of association agreement with the EU as the full horror of Brexit sort of takes hold. And you may find that these questions under EU association agreements with third countries, there are often rights, including coordination of social security provisions for people, which become more connected even for non-member states. And so some of the learning in this area that you have now isn't going to be wasted in years to come, as anybody who has ever dealt with, when we were in the EU, with Ankara agreement cases between Turkish citizens and Turkey and the EU will remember. The Ankara agreement had lots of things that looked a little bit similar to free movement law in some respects, and which relied on EU law concepts. And so it's worth keeping your hand in, because things change, fashions change politically, and we may find a more intimate relationship with the EU in years to come. Thanks very much.
Thanks so much, Adrian. Yeah, a lot to cover, which you managed to do really concisely for us. So thank you so much. I had a twinge of fun nostalgia for your sort of rattling off of the different EU rights to reside and the kind of levels of inquiry that you have to go through when trying to work out if somebody's actually eligible for something. I always remember one of the most common mistakes that I found that decision makers made was forgetting that under the directive, you're a child until you're 21 rather than 18, which is always a really nice surprise when you can point that out, that actually you've got another 3 years of dependence to rely on if you're dealing with a young person. So yeah, thank you to all of our speakers. We've still got some time for some Q&A. So what I'm going to do is just give our speakers a minute just to scan through some of the questions, just to sort of give yourself a bit of prep time before I dish them out as I so choose. But whilst we're doing that, I just wanted to sort of give a shout out really to I suppose to the potential for exceptional case funding under Section 10 of LASPO, for those who are working in this area who may be concerned that maybe funding is going to be a problem for clients who would normally be financially eligible for legal aid. Just to give you an example, I'm currently instructed, or I have been recently instructed in at least 2 cases at first tier tribunal level, because the solicitors working with me have managed to get exceptional case funding for their clients. Dealing with Universal Credit, ESA, I've had a PIP case, I think, instructed in the first tier at ECF rates, and it can be done. It is worth your time if you have the stomach to deal with the legal aid agencies sort of bureaucracy to do it. But I think it genuinely is worth it. And just to give a shout out that the resources on the Public Law Project's website on exceptional case funding, including the guide on how to get ECF for welfare benefits cases, is still good law, still good guidance, and definitely worth a look. So just to give a shout out to that option, because yeah, some of the issues that we're dealing with might be resolvable by means that are in scope under LASPO, like judicial review, but some of them won't be, and so ECF is definitely worth considering. So yeah, I just want to sort of put that out there in terms of thinking about remedies for our clients. All right, so I'm going to look at some of the questions and comments that we've had come through. Thank you all so much for those contributions. Just since I think just for sort of convenience, and just because you spoke most recently, Adrian, I'm just going to throw open to you Dan Manville's question about the case of CG. So Dan asks, how does CG apply to third country nationals who came as EU family members or durable partners and then separate? Anything you can help us out with there?
There's two questions. I mean, durable partner, as everyone knows, is an extended family member relationship, and so you're not lawfully resident until the registration certificate or residence card is issued in reliance on that. And of course, a durable partner is an unmarried partner. the status of it. You don't have to live with your family members under EU law under the same roof. You could, so long as you're both in the territorial jurisdiction, that's sufficient for EU law. That's a case of Diatta against Land Berlin. So the what you could do is, if you're lawfully resident as a durable partner, then the question becomes, how do you measure the separation in that context, because given that you don't have to live under the same roof? And you would argue that you remain lawfully resident until such time as the residence is curtailed in some fashion in those circumstances. So it'd be very difficult in some respects to establish that you were no longer lawfully resident absent and on the EU right, unless that registration certificate or residence card had been curtailed. So for all practical purposes, because you can cite this case that you don't have to live together, you could bring that as an issue. Cohabitation and the 2 years of cohabitation is it was the Home Office yardstick for granting the permit, but not a condition of thereafter once it had been granted. And so the same is true for family members, direct family members generally, who are not extended family members. You don't have to live with your children or your spouse or a civil partner for them to be able to rely on the rights. They just have to be present in the territory with you.
Great, thank you so much. All right, I'm going to throw a question from Mark to Bethan, if that's all right. So Bethan, Mark's asked you about the white paper on the fair private renter sector point. So Mark's asked, did you say that the white paper deals with landlords refusing families of children as well as those with no DSS in quote marks? And does any of the case or deal specifically with that issue, or whether you happen to know if that's being pursued?
Yes, well, there may be other people here who are aware of possible moves to take that issue up. I mean, I can confirm that it is in the white paper, blanket bans on renting to families with children or those in receipt of benefits, the no DSS bans. But I'm afraid I can't sort of enlighten on the first aspect of that. But there may be, if anybody is present who has some awareness of any kind of research that might be going on in relation to that matter in particular, because obviously that's essential to really moving forwards on these sorts of issues, like the shelter research was so essential on the case law that we have seen in relation to the blanket bans. It would be really helpful to know about it. I mean, it really shows the problems that there are in the private sector overall. Alongside that, if I could perhaps just under that heading also respond to the point that was made by Samantha Maher, who has highlighted that her clients are also facing a requirement for guarantors who can show wages of 35 to 40,000 pounds, and also maybe need to be homeowners, and people who are dependent on benefits, obviously less likely to be able to come up with that. So this is no DSS by a different route, essentially. So, you know, obviously there's just so many battles for people to fight in the private sector, is what that's telling us. Yes, so that's, I just wanted to deal with that one. Shall I respond to some of the other ones that
by all
Matthew?
means. Sure.
Yeah, okay. I mean, Desmond might also be able to contribute on some of these, but thank you very much for the point that was raised by Rachel Lovell, who was highlighted in the breathing space regulations, regulation 10, subparagraph 3 and 5. And this is very important. So thank you very much. So regulation 10.3 states that you, if at the start of a moratorium, any action or proceeding that relates to the moratorium debt is pending, then the court is pending in a court, then such action or proceedings may continue until the court or tribunal makes an order or judgment or conclusion of such proceedings. So the proceedings, if they'd already been started, can continue. But then it goes on at 5 to confirm that during the moratorium period, the court must take all steps to ensure that there's no enforcement of the order or judgment. So one needs to look at notices, starting of proceedings, continuation of pending proceedings, enforcement, when one looks at where, at what point the moratorium bites, but it's specifically targeted at the actual enforcement itself, as we can see from that. So that's why you might still get possession proceedings, of course, going on even where there is a
yeah. I wondered if the use of the word may in 10.3 as opposed to must in 10.5 means that the court's got a discretion to continue proceedings where there's a moratorium.
Well, thank you for that. That's a really good point. And if there's anyone here who can comment quickly in the chat on that point of detail, that would be gratefully received, because it's there's certainly a lot to learn about the scheme. Then Jackie Brown, thank you very much for highlighting a point relating to being able to the notification to creditors that the person's actually on the breathing space scheme. And I noticed that regulation 25.2, it does say that once the Secretary of State has received all the information from the debt advisor, then within that working day, I think it says by the end of the following business day, that there should be notifications sent out to the creditors about the moratorium. But it may be that creditors just don't really sort of note it straight away. I noticed in the report from Step Change about the experience of the scheme, one of the points that was made was that creditors weren't aware, this is quoting somebody, creditors weren't aware I was on the breathing space programme. Once I phoned the breathing space department, they sorted it out very quickly. So there does seem to be some sort of potential kind of communication issue there, that sometimes the person, the debtor themselves, needs to actually sort of get the system working so that it actually kicks in. Then the question was asked, and it may be that Desmond would want to comment on this as well from his experience, as to why is it that landlords don't want people who are on housing benefit? Because surely there is a lot to be said for getting the housing benefit paid directly, which obviously can happen to the landlord. And of course, that's a very good question. I mean, my sort of insight into it, for what it's worth, is that there is still a feeling that housing benefit is unreliable as a source of payment of rent, and that it's always paid late, and that there's also prejudice against people who are on benefits. But it may be that others have got comments, or whether that is also their experience.
I think you put your finger on it. It appears unreliable, and if there's an interruption, the interruption can just go on forever. And put into one side the fact that there's always a shortfall. Yeah,
I think I'd agree with that. I think especially before universal credit was rolled out more comprehensively. If a client was on another income related benefit like ESA or something, like, or job seekers or whatever it might be, and that benefit was stopped or suspended, then that would lead to housing benefit then being suspended as well, inevitably. And so I think that perception of unreliability, late payments, the shortfall, and sort of general prejudice as well, I think is a sort of combination of those factors, I think. Great, thank you so much. I think we've covered just about all the questions that were put into the chat. So thanks again for everybody for your contributions. Thanks also for the very shout outs we've had in the chat as well. So Claire has highlighted there's a designated lead case in the upper tribunal on the application of CG in relation to a refusal of universal credit post end of the transitional period, which is due to be heard next month. And Dan Mambles has highlighted as well that there's a newly opened ECF clinic based at the Liverpool John Moores University, which is taking referrals nationally to help with the ECF application. So sounds like a really, really good initiative that's recently opened up. So again, just to highlight that the use of ECF as a potential way to get funding for some of these issues. So aside from that, thank you again to all of our speakers and for all of you for your attention and for your contributions. I hope that was all useful. As I say, you'll get the recordings and the slides sent around in due course. And yeah, thanks again. Hopefully we'll see you all again soon, whether it's on a webinar or in person. Enjoy the rest of the evening.